Environmental law is a specialisation. And if you look at a report like the LLB Curriculum Research Report, which was brought out last year, they talk about the purpose of the LLB and they really emphasise generic level skills like writing, like researching, ability to work with the law, and less emphasis on the specialisations. So my view is that environmental law will remain a postgraduate option. And students also come if they believe there are work opportunities. So it's a case of work being out there, people going out, establishing themselves, establishing firms that specialise in environmental law, and then it will grow. But certainly I think there is space for more people to become involved in this field. There are a number of firms that have specialist environmental law departments. There are also other ways of getting involved, going to work for governments, working for these newly established, for instance in the water sector, the catchment management agencies sorely need people who actually know the law. So yeah, I do think there are opportunities, but I think it's slowly evolving that more opportunities are coming and people are becoming more interested. But I think what we do need is more awareness, particularly in traditional fields like companies law and contracts law, of the environmental implications of some of the disputes that they deal with. For instance, in companies law, the King reports, the second and third King report clearly emphasize that environmental sustainability is an important part of the duties of a company. So we need more integration of an understanding of these issues in these other subjects. Environmental law is a vast field. There is, just to understand the National Environmental Management Act and the EIA process is a 6-month course. Then there are separate regulatory regimes for biodiversity, for energy, for water, for land, for mining, for, there's just so much. And they think of Waste Act, air quality. So the students come and they get frustrated because they think, I want to answer this question about waste law. And no, we've got a whole separate course on the Waste Act. So there's an people underestimate how broad the field actually is. And also with that, there's a need for specialization. You actually can't be an environmental law specialist in all those fields. So my colleague and I try and divide the fields up between us so that we can at least kind of specialize. But it makes it difficult to kind of know what's happening in every area, because it's dynamic, it's developing every day. There are new regulations, there's amendments to the acts, there's a new act. Yeah, so it's complicated. Because we're teaching at a university, we feel that our education should be distinguished from what people who are just offering kind of, nuts and bolts of EIA. So we try and incorporate a critical perspective to looking at environmental law. So it's not just this is the law, it's also thinking about how appropriate is the law, how could it be different, how does it relate to the constitutional standards relating to the environment, and so on. And students sometimes, they struggle with that. They just want to have I just want to know what to use. I want to make sure that I'm not in non-compliance. So we have to strike a careful balance between focusing on the context and the text, and which we do try and do. But we would never get rid of that critical perspective on the law. I think that's very important. Because this is a new area of law, like most of our environmental law statutes are post-1994, there isn't a lot of jurisprudence. So you have the statute, but you don't have the interpretation of that statute by the courts. So you can't offer students the same level of certainty. So for instance, like last night we were discussing criminal liability, and directors of a company can be held liable unless they prove, for acts of pollution, unless they can prove they took reasonable steps. Now how do you interpret reasonable steps? So in companies law, you might have a number of cases that have developed over the years which give people certainty in what that means. But in environmental law, we don't have it. So sometimes it's you give the perception that, well, we actually don't know because we can't really say. We can look at this case from Canada, we can look at this case from Namibia, but what the court will say is not clear. So that's what makes it seem like a bit of a uncertain or iffy subject. But it's just the case that it's still developing.